conditions and extradition issues. I will first talk about a concrete case illustrating these issues, and then afterwards I will talk about the latest news concerning the detention conditions in Romania before giving the floor to Mr. Dragomir from Romania and to David Clark from the UK. It's today the 24th of January, and exactly a year ago, Dan Adamescu died in a hospital in Bucharest during his detention at the age of 68. He was then serving a prison term of 4 years and 4 months. A few days before his death, I and a colleague were in Bucharest to collect some information about prison conditions and the situation of the judiciary. At that time, there were huge demonstrations on the streets of Bucharest, and well, as you could see from the recent news, nothing has changed. Dan Adamescu was a businessman and also the owner of the newspaper Romania Libera. Romania Libera, one of the oldest newspapers in Romania. It was founded in 1877. It is an independent media. Of course, it was suspended. Its activities were suspended during the regime of Ceausescu, during the communist period. But when he disappeared from the national and international scene in 1990, so Dan Adamescu took over the newspaper and used it as an instrument to promote democracy and the rule of law, but also to expose corruption in the Romanian politics and the bureaucracy. Needless to say that this sort of activities didn't attract any friends to him, especially from the politicians that he was criticizing. May 2014, he was imprisoned in Romania after swift showed trial and sentenced, as I said, to 4 years and 4 months on charges of bribery and corruption, accusations that he and his family vehemently denied. His family contend that he was falsely convicted on the trumped charges because the Romanian state wanted to control his newspaper and expropriate his businesses. So his family also say that the conditions in which he was held in prison and the lack of appropriate medical care contributed to his early death. A few days before he passed away, he had asked to be released on bail on health grounds, but that was denied by the anti-corruption agency, although there had been a positive opinion of the Ombudsman's office. But my story does not finish with the death of Dan Adamescu, because his son now, Alexander Adamescu, who lives in London, is a playwright there, has been fighting first for justice for his father, and has also become the target of the Romanian authorities, who are requesting from the UK his arrest and his extradition. He is accused by the anti-corruption agency in Romania of committing precisely the same crimes for which his father was convicted, and based exactly on the same evidence, that's to say, one tainted prosecution witness. Romania issued a European arrest warrant against him on the 6th of June 2016. He was arrested in London, released on bail, and his deportation, which has been requested by Romania, is still pending. It's significant that a European arrest warrant was issued only after Alexander Adamescu had protested against the treatment of his father in prison, and never before. And also as soon as he had instructed lawyers to file an arbitration proceeding for the amount of 200 million British pounds against the Romanian government for the politically motivated seizure of and liquidation of his father's companies. So now, second point I wanted to address, the prison conditions. 1 year later, what's new about the detention conditions in Romanian prisons, and why is this issue important? Detention conditions are an essential element in the fundamental human rights architecture. This criterion is all the more important that when there is a serious deficit in this regard, an EU member state can refuse to hand over a person who is requested by another member state. So there are a number of reports, negative reports about the detention conditions in Romania. You have the one of the US State Department. You also have the one of the Ombudsman's office in Bucharest. Also the report of the Committee of Prevention of Torture of the Council of Europe, the Universal Periodic Review of Romania raised this issue as well a few years ago, and quite recently also judgments by the European Court of Human Rights. There were already a few in the last few years, one in 2007, one in 2010, another one 2012, and last year another one. The 25th of April, the European Court of Human Rights released a judgment in the case Resmives and others versus Romania, and held unanimously that there had been a violation of Article 3 of the European Convention, so prohibition of inhuman or degrading treatment. The applicants were former detainees, detained in several facilities in Timișoara, Pelandava, Baia Mare, Focșani prisons, and they complained in particular about a number of issues: the overcrowding of the cells, the lack of space, the mould on the walls, the lack of natural light, the poor ventilation. This list is really in the judgment. The lack of hygiene, the inadequate sanitary facilities, the poor quality food, very short duration of daily walks, and so on and so on. Due to the repetition of such cases being brought to Strasbourg, the court decided to apply the pilot judgment procedure, finding that the applicant's situation was part of a more general problem originating in a structural dysfunction specific to the Romanian prison system. Under Article 3, the court held in particular that oh, sorry, I will switch off. Just a minute, sorry. Yes, so that held in particular that the conditions of the applicant's detention, also taking into account the duration of their incarceration, had subjected them to hardship going beyond the unavoidable level of suffering inherent in detention. The court held that the state, so Romanian state, should introduce a number of measures to reduce the overcrowding and also preventive remedies. I will not go into the details. Under the pilot judgment procedure, the court decided to adjourn the examination of any pending case, whatever the level of the procedure, and gave 6 months from the date on which the judgment became final, gave 6 months to the Romanian government to provide, in cooperation with the Committee of Ministers, a precise timetable for the implementation of general measures. In 2019, so this year, the Council of Europe Committee of Prevention of Torture plans to visit 8 countries, and one of them is Romania. So this thing should be followed very closely in the next few months. I will stop here about my presentation on prison conditions, and I will give the floor to Mr. Dragomir, who is a former lieutenant colonel at the Romanian Domestic Intelligence Agency Counterterrorism Brigades. The floor is yours.
Thank you. Thank you, everybody, for being here. We have here two very reputable and respectable and well-known speakers, Mr. Fautré and Mr. Clark, so I will have to introduce myself for a couple of minutes. I was born in a small city in Romania, in Bacău, in the middle of Moldavia, and I joined the Romanian National Intelligence Academy, that is a military academy attached to the secret services, in 1997. I graduated this academy in 2001 and joined the ranks of the Romanian Intelligence Service, which is the Domestic Intelligence Service. And I was part of the Counter-Terrorist Brigade. Counter-Terrorist Brigade is the specific unit of the service that deals with terrorist threats. And I went up the ranks until January 2013, when I decided to resign from the service. And I resigned from the position of deputy head or deputy chief of this unit, Lieutenant Colonel, as Mr. Fautré said. I was trained and I was prepared all my life to fight terror. I never believed that I will be forced or I will have to fight the terror within our own ranks and the terror within Romania's society. Because what is happening in Romania in the last years, it's a clear, what I call parallel state actions against the population. And I will try to give you today examples, and I will try to provide today a clear image of what happened in Romania in the last years. The first thing that I would like, and I am here to bring you only bad news, just to say it from the beginning. The first thing that I would like to emphasize is the fact the biggest fake news of Europe and the biggest fake news of Romania in the last years is called Laura Codruța-Kövesi, the head of the DNA. The DNA is the Romanian Direction for Anti-Corruption Fight. And I have to say it from the very beginning, the fight against corruption is very commendable and is very necessary, especially in a society and in a country like Romania. Because we all know the history of our achievements in the last decade. I would like to emphasize another thing. 99% of the Romanian population supports the fight against corruption. Do not believe the Romanians on the streets that were mentioned before by Mr. Fautré or other Romanians do not understand how necessary this fight is for the Romanian economy and for the Romanian development. But on the other hand, we are a nation that has been through 50 years of communism and 50 years of abuses. So we know very well our past and our traditions and our history. So why I wanted to mention this fake news? Because the anti-corruption fight in the last year started to be an element of pressure and attack against the opposition, either political, economical, or other type of opposition. As I said to you, I left the service because I did not agree with the vision of the service at that time in January 2013. That means the leadership of the service started to be more and more involved in the political game. And on 12th of January 2015, I was picked up from my house, together with my wife, by the DNA, with a file. My children were taken to the school, the bigger one to the school, the smallest one to the kindergarten, by the DNA police, because both me and my wife were picked up and taken to the headquarters of the DNA. And a fire started against me. I stayed in prison 6 months and a half in 2015 and another 6 months in 2016. So when I'm speaking about the prison condition or the detention centers, I think I know what I'm speaking about. What I'm saying is the biggest fake news, and I will give you only one example. Lying, it's part of Kövesi's PR campaign. But in the last period of time, this lie started to fall apart. A recording was put out on the Romanian media where the head of the DNA was asking for ordering files against picking up on the Prime Minister, files on ministers, and as many files as soon as possible for the DNA to survive. So the political involvement of the head of the DNA is very obvious. She went out and she claimed that this recording is not true and is false. An investigation of the Prosecutor General decided that this investigation of this recording is not false. I put out last week some news regarding the file that she sent an email within the organization, and she called the prosecutors that made the recording, because there was an internal meeting, traitors, cowards, criminals, and that she asked for warrants in order to search her own prosecutors in her headquarters to understand who made the recording. She went out publicly and she denied it. She said, no, it is not true. A few days after, a report of the judicial inspection in Romania put out a clear document saying that she obtained these search warrants and that that email was really true. More than this, that she tried to delete the email and she did everything necessary to delete it from the servers of the DNA. So this is something that I consider to be extremely serious. Second issue, the issue of Romanian prisons and detention centers. I will call them very simply, I will call them a gulag. Gulag is a Soviet-era term that describes very well the situation in Romania. Of course, the authorities are reporting and they are putting out a lot of interesting press releases, but I brought you pictures. It's interesting for you to see, and I will pass it along the table. The conditions and the real pictures from Romanian detention centers and prisons. As I said, I was 6 months and a half in one of those detention centers, and we were on 12 meters square, 8 persons. Mr. Fautre mentioned before the case of Dana Damescu. Just to be very blunt and very clear, because the Romanian propaganda already started to attack me and attack my presence here today with you on these grounds. I never met Mr. Adamescu. I never had any business with Mr. Adamescu. We were never in contact. We had nothing in common, let's call it. There is one thing that we have in common. Still. In January 2015, when I was arrested, and I was placed on solitary confinement in one section called maximum security, section 4, one of the guards came to me and he told me, you know what, this bed that you're staying in is the bed where Adamescu was put when he was in pre-trial arrest. So the only connection between me and Adamescu, or the death of what happened, or the story, this horrible story that happened, is the fact that we shared actually the same bed in the same gulag conditions. I will add something to this case. When the lawyers asked in December 2016 the release of Dan Adamescu, he was in coma. He was not able to communicate in December. And the DNA came to the judge and said, no, we cannot do this because there are two things he did not show. Why I'm mentioning this? Because in 98% of the cases, this is what they are claiming. One, the fact that we have no proof he changed his behavior and he understood the acts he committed. Second, that he did not show any sign that he regrets his acts. So for you to better understand this, we are talking about the inquisition that is taking place in Romania. If you find a better term to describe, be my guest. But the fact that you have to acknowledge and you have to admit the facts that you are accused of, even if you declare yourself innocent, and then you can be put on parole or released on parole, I am calling this inquisition. Thirdly, a lot of the people that are on the streets and other people that are, let's call, supporting or protecting the Mrs. Koveshi, I will have an argument regarding this. A lot of the fight in the last years that certain of us are doing is to try to put the European laws and the European directives into place in Romania. One of the big discussions in the last days is the fact that, and I'm explaining this to you, from my point of view, the presumption of innocence in Romania was arrested and was already convicted, and there is no presumption of innocence. There is a European Union directive on this issue, and we are trying to impose it, or to take it into the Romanian laws, and we have in front of us a big fight from the DNA and other circles. Why? It's very simple. If you want democracy, if you want freedom of the speech, if you want freedom of the citizens, it's very simple. Let's take the European directives and laws and submit it into the national legislation. Why do you attack this? The international warrants. From my point of view, the international warrants and the red notices with the Interpol and the European arrest warrants are a very clear sign of where Romania is standing now. I used the term in the last period of time, I used the term Securitate 2.0. Securitate 2.0 is the former Securitate that some of us, we might remember from before '89, and what is happening actually now in Romania. We are next to the Russian Federation and to Turkey in the number of international warrants. Second, we are next to the Russian Federation and to Turkey in asking to grab, to catch the opposition, even if it's political or economical, like in the case of Adamescu or his son. So this is an abuse of international warrants. The numbers are very strict and very clear. Let us look at the numbers. Let us identify the targets. And you can see right from Eastern Europe, we are the only nations that have dozens and dozens of warrants against the opposition. My message to the European Union is the fact that the European nations should understand this abuse of European warrants. Why? Because the European nations can be considered accomplices to this Romanian authorities' actions. When I said Securitate 2.0, I'm going to the most important topic of my last presentations, is the collusion between the security services and the judiciary. One of the things that the people asked the most in '89 when they went out on the streets was the fact that Securitate cannot arrest, detain, prosecute, and judge people. We managed to do this. The current Romanian security services do not have this legislative possibility. But what they tried to do in the last years, with these secret protocols signed between the DNA and the security services, was actually exactly that. There are proofs in Romania that the security services were involved in the judicial process. There are proofs that the security services got involved in the real judgment, denying the right of fair trial. And there is a commission, a permanent commission of the Romanian Parliament, the control commission of the SOI, that is taking into consideration all the things. I went in front of the commission, I presented these proofs and documents. I submitted the commission a list of 65 names of people that were abused, or people that were part of this conspiracy, of this parallel state, that is behind a lot of the actions and cases that are currently taking place. Of course, everybody will say, maybe he's fantasizing, maybe he has a file, maybe, as the propaganda is saying, he's working for such or such or such person. I'm not. And I know, from my experience, that the arguments and the numbers are the most important. So one of the things that the Securitate 2.0 is the most clear and present in the day-to-day life of the Romanians is the large-scale, the mass-scale surveillance of the population. And here are the numbers. Between 2010 and 2015, so 5 years, first you have to know that there are two types of surveillance warrants in Romania. One is national security warrant that is obtained by the intelligence services. Second is the normal security warrant. We're talking about normal surveillance warrant. In Romania, 946 requests were were asked in these 5 times, and the courts in Romania agreed to 729 applications. So in these 5 years, 729 warrants were issued. You need to be explained something else. In December, I showed to the public one of these warrants. In these warrants, there were 80 targets, 80 persons. Starting with the head of the Senate, the second person in Romania of importance, the president of the Senate, that was during that time presidential candidate, a list of 80 persons, political, economical, media, journalists, that were on that specific warrant. Second thing, the High Court of Cassation and Justice, during these 5 years, was asked to issue 4,523 warrants. They admitted 4,522. So they rejected only one in 5 years. As you know, in Romania there are appeal courts. The appeal courts include Bucharest, Iași, Timișoara, Oradea, and Pitești, accepted during this period 100% all the requests. So you do the numbers. This report is obtained, and this report also here contains the numbers per each request and admitted warrants. And I will go to the second issue, the issue of the national security warrants. Regarding the national security warrants, one of the persons that was interviewed by the commission in the parliament, and I'm talking about Alina Bica, the former head of the anti-mafia prosecutors, she said in front of the parliament during an investigation, I mean under oath, she said that while she was heading the DICOT, while she was actually part of the Prosecutor General, she was signing this type of warrants. And she said that there were mayors, presidents of counties, athletes, businessmen, people from the media. And she said that she signed each day between 16 and 20 mandates per day. And that as far as she remembers, usually on one warrant there were about 10 persons, 10 targets. And she said that she did this activity for about 1 year while she was in that position. And that there were 2 prosecutors from the prosecutor's office that were signing this type of warrants. So again, you can do the maths and the calculations. It's very simple. This large-scale surveillance, that warrant that I showed in December is very clear, means physical surveillance, electronic surveillance, surveillance inside the house of the targets, surveillance regarding the emails and all other type of communications. So all this large-scale surveillance that I'm presenting you, you should understand that is also touching the European citizens, because European citizens are in contact with Romanians. The European businessmen are in contact and doing investments in Romania. So this is also an European issue. The head of the judicial section of the SRI was interviewed for about 6 hours in the parliament. His name is General Dumbrava. Among other things, he admitted that he was asked to give judicial opinion to prosecutors and to judges. So, a security service that has no right by the Constitution, and that the Constitutional Court said it very clear and loudly that is against the Constitution to be involved in this type of activities, was actually in collusion with judges and was asking the judges the penalties and the number of years that the person should be in prison or not. The request to grant or not the request of pre-trial arrests. I will give you another example that you will understand. You know, there is a Sky News reporter called Stuart Ramsey, and he made a report in Romania about 1 year ago. He was accused of organized crime, organizing a group, and he was accused of revealing information that is putting in danger the Romanian national security. Why? Because he made a show on TV, and he explained the basic line was the border between Romania and Ukraine is so porous and has problems that we might have arms going through Ukraine to Western Europe. Anyway, the quality of the show is not really up to me to decide. But the important thing is the Romanian prosecutors, they started a case against the journalist. And they asked the Rogatory Commission to the UK because he's indicted in this case actually. He's already indicted. So this is the type of activities that are done currently. More than this, when I called in Romania, when I call these activities, I call this activity tortures. Why? There is a term in Romania that sounds and is very understandable, called torționar. In English would be translated torturer. Because the torture doesn't necessarily have to be physical. The torture can be a torture against the against the family, psychological, against the family, against the business, against the employees. Because in the last years, we saw Romanian businessmen being destroyed. We saw businesses being destroyed and people let out on the streets. We saw destinies destroyed, like again, it's the case of Dana Damescu. And we saw a gulag situation. I was, again, imprisoned for 1 year and a month, let's say. Because of my military formation, I was, let's say, ready to live in those conditions that I showed in the pictures. Normal persons, they are not ready. You mentioned, and I will end with this, and then we will come back if you want to discuss any specific action. You mentioned a committee that is going to come to Romania to look for the prison conditions. We are like, I don't know if you know the story of the Potemkin villages in Russia. We are exactly in their position. So if this commission is going to Romania, my first advice would be for the commission not to go and see what the authorities want to show them. Because I've been there while one of this commission came. And they set up a room, and it was very nice, and they put TV, and they put only 2 people in, and they take out the other people and putting them in a different way. And they asked us to smile, and they asked the people to smile. You can imagine that they were smiling, because if they were not smiling, they would lose a lot of the things they had granted inside. So this type of lies have to stop. And one of the most important things the gulag in Romania is not about the people that are put into prison. It's about the lack of fair trial. The lack of fair trial is very difficult to understand in the Western European society. The fact that you are in front of a judge, and that judge is actually a secret agent of the security service. The fact that behind the closed doors, a general from the security services is going to present a secret classified report to the judge and says to the judge, you cannot show this to the defendant. You cannot show this to the lawyer. You cannot show it to them. But keep in mind, we have this information and this person is guilty. And that judge is taking decision based on that. This is making Romania not a part of the European Union, but is making Romania part of a much Eastern culture of dictatorship. I will be ready to answer any of your questions, and probably there are a lot of other things we're not able to discuss. But again, David, I think, has more interesting things to say.
Thank you for your testimony. I must say it's quite frightening to hear about your experience from inside of those institutions.
Also, I will show you 2 pictures because, you know, one of the things that they are using, they are using the media in their activities. So when I was arrested, even if the Romanian directive is not allowing this, but we did not implement it. Why? That remains to be seen. They were taking pictures of me while I was arrested, then they were putting them out in the media. Why? In order to attack and to say, look, this person has no right to speak. This person is guilty. So I will also pass it through the table, because I'm not very proud of these pictures, but in the same time they're part of my past.
History, your personal history. Okay, thank you very much for sharing this horrifying experience you went through. And I will now give the floor to David Clark, political expert on Eastern Europe and former special advisor at the Foreign Office from 1997 to 2001.
Thank you very much indeed. Well, that was very interesting, and it overlaps with an awful lot of what I know about the situation in Romania and have looked into personally myself. I'm here because a year ago I wrote a report for the Henry Jackson Society in the UK called Fighting Corruption with Contricts, Romania's Assault on the Rule of Law. And this caused quite a stir, because although all of the information that I used was in the public domain, and I'd assembled it in that way, it was the first time anyone outside Romania, any reputable think tank outside Romania, had really brought that information together and presented it in the way that I did. And the conclusion that I came to was that in Romania the anti-corruption fight had become, in a sense, a cover for political score settling and extremely serious violations of human rights that put Romania in breach of its European obligations. In essence, I was arguing that the anti-corruption fight in Romania had itself become corrupted in a very fundamental way. Now, the reactions to this were several. A lot of people welcomed it. There was a fair amount of surprise and shock, I think. My own motives were attacked by those who were unwilling to hear what I was saying. And the DNA, the Anti-Corruption Agency, made a formal referral of my report to the Superior Council of Magistracy on the basis that it constituted an attack on judicial independence, of all things. The very problem I was highlighting in my report, which I'll come on to, which is the extent to which prosecutors and politicians are undermining the rule of law and undermining judicial independence, was something that I was accused of in a startling example of what I would call Soviet-style doublethink. And the CSM eventually produced its finding, a very diluted and tangential ruling in which they, more or less without saying so, tried to imply that the DNA's assessment of my report was correct. A very clear tool of intimidation, I think, intended to be a tool of intimidation against me and against the organisation that I was writing for. Not that it particularly succeeded, because I'm not easily intimidated and I'm not within the reach, thank goodness, of those who have any ability to do me harm. But a clear indication of the mentality of the people that we're dealing with, their attitude, as demonstrated in the Stuart Ramsey case exactly, of an intolerance to anybody who questions their methods and looks closely into what they're doing. The one thing that hasn't happened a year after I wrote my report is I haven't been challenged on a single point of fact or analysis in my report. There have been plenty of ad hominem attacks on me personally, but nobody has questioned a single fact or point of analysis in my report in any way that would force me, as somebody who takes a certain amount of intellectual pride, to reassess my conclusions. And my conclusions were damning, and I'll go through them here again. And the conclusions I think that any fair-minded person would come to if they looked objectively at the evidence. One is that justice in Romania has become heavily politicized. That was my first conclusion. And the anti-corruption fight has become, in a sense, a political football within Romania. Public anger, justifiable public anger at the level of corruption in Romania, has been abused by politicians, by law enforcement and justice bureaucrats to entrench their power and pursue goals which are covert and not declared and have nothing to do really with fighting corruption. There's a clear partisan pattern to the way that prosecutions in Romania have unfolded over the last decade and earlier, in fact. As an example, I'll cite the 2016 local elections, which was preceded by a rash of prosecutions and indictments against primarily politicians from the PSD, the Social Democrats, who at the time were in power, often involving the resurrection of old and outdated case files to try and obviously influence the results of those local elections. I don't say that because I regard the PSD as angels at all. They themselves have been amongst the worst offenders in this battle. And there's a pattern in Romania in which the victims then become the perpetrators when they're in a position to do so, and then become the victims again when they're out of power. This is a very clear sort of cyclical sort of pattern to the way these things unfold in Romania, unfortunately. The second thing I identified was a very unhealthy relationship between prosecutors and politicians. The separation of powers in Romania is not respected in any sense that I can discern. Politicians at times are able to manipulate prosecutorial appointments. The most obvious example of this being in 2013, the deal between President Băsescu and Prime Minister Ponta, in which they agreed to split appointments according to their own preferences. Băsescu got to appoint Laura Kövesi, Ponta got to appoint the Prosecutor General, and various other appointments below them were dished out on a partisan basis. The people who were the beneficiaries of those appointments presumably then expected to act loyally on behalf of their patrons. And at other times, prosecutors have reversed the tables and have targeted politicians. Daniel referred to the Kövesi tapes, which emerged last summer, in which she quite clearly states that she wants, as an act of revenge against the government for attempting to clip the DNA's wings, a string of case files to be brought forward against the Prime Minister and other ministers. So what you have there is something which I think is very typical of the DNA's methodology. They fix the target, the person they want to get, and then they assemble the evidence around the target as an afterthought. A very clear violation of the DNA's proper constitutional role, a breach of law, in fact, and certainly an abuse of office that in any functioning democracy would have led to her dismissal straight away, and yet she's still there. The third thing I identified was a covert role of the intelligence agencies, which is extremely unhealthy and involving a very close relationship with the DNA, in which the SRI is quite clearly the senior partner, and the relationship works in the following way. The DNA gets access to the SRI's operational capabilities, particularly their wiretapping capabilities, which enables them to burnish their reputation by gathering evidence that they can use in prosecutions, to increase their prosecution rate, and prove to the Romanian people and the international community that they're an effective law enforcement agency and from which they benefit. What the SRI get in return is the ability and the right to direct prosecutions against their chosen targets in a covert way. And this is something that emerges very clearly from the testimony of Alina Bica, who, as Daniel said, was the head of the anti-terrorism and anti-organised crime agency, DICOT. She said quite clearly that the reason that she was targeted eventually for prosecution herself was that she refused on several occasions to do the SRI's bidding in indicting individuals that they wanted to pursue. And the individual involved in that was a senior SRI officer called Florian Koldia, who Daniel will know about very well, who was then, as a result of allegations about a year ago, forced to step down from his position. I think he still remains on the reserve, however, so he's still part of the system in some way that those who are not in the system are not quite able to discern, but he's there but not there. But a clear recognition, I think, that he'd become an embarrassment to them in some way. So he was shunted aside. And then we have the admission from another senior SRI officer that they regard the judicial system as a tactical field of operations in which they retain an interest, directing prosecutions right to the end. Admissions from former SRI director, now ambassador to the US, Mr. Mayer, that the SRI run penetration agents inside the media, staggering admission, something that's completely out of kilter with the functioning of an intelligence agency in a normal democratic society, something that's far more redolent of communist era practice. The strong suspicion that has been raised by the Romanian Union of Judges and others that the SRI also run penetration agents inside the judiciary, again reminiscent of Securitate practices from the Ceausescu era. Very clear indications to me that some of what the SRI are doing is motivated by the desire to play a sort of kingmaker role in Romanian society and Romanian politics, spotting compliant politicians that they want to advance the interests of, punishing those who will not do their bidding, and also potentially, I think, in at least two cases that I'm aware of, a motive of financial gain to people associated with the SRI. So in a sense that prosecutions directed by them through the DNA essentially comprise a kind of attempt at corporate raiding, I would say. So what I would say is that we have a situation now in Romania where the domestic intelligence agency is out of control, which should be a concern to every country that is a partner and an ally of Romania. The fourth thing that I identified was the extent to which judicial independence is compromised in Romania, compromised by politicians, but compromised most of all by prosecutors. Judges, there are cases where judges who have angered the DNA have themselves been targeted for prosecution. There's a clear conflict of interest in the sense that the DNA not only has responsibility for pursuing anti-corruption investigations generally, but also pursuing corruption within the judiciary, which is, of course, judges understand very well, so they constantly are aware of the fact that they themselves could be targeted for prosecution, and will have known and will have seen that some of their colleagues have suffered precisely that. This, to me, explains the extraordinarily high conviction rates in excess of 90% in anti-corruption investigations. And it explains the next part that I'm going to talk about, which is the fact that the judicial system is heavily tilted against the rights of defendants. The judicial system is heavily skewed against the presumption of innocence and in favour of a kind of presumption of guilt. We have cut and paste justice often. Judges' rulings, if you read them side by side with prosecutor submissions, are often reproduced word for word. The judge's ruling will simply involve copy-paste from one document to the other without any input or judgment of their own, reflecting, I think, the fact that judges are intimidated or afraid or perhaps compliant for some other reason. And this is just one of a number of very widespread abuses of process. Denial of fair trial, which has been, I think, shown in rulings by the European Court of Human Rights. Romanian justices of the right to fair trial are up there with countries like Turkey and Russia, not in line with other EU countries. There are examples of suspects being given immunity from prosecution in exchange for their willingness to implicate more important political targets. I was interested to note in Daniel's comment that when he was arrested, they also arrested his wife. This is very common DNA practice, is to target family members of suspects in order to exert leverage and to intimidate. Very, very common practice. In fact, in almost all of the cases that I looked at in preparing my report, there were examples of family members being targeted in this way. And also something that I think Daniel referred to, the systematic leaking of evidence to the media. Evidence that can only have come either from the DNA or the SRI, often involving intercepted telephone conversations, the transcripts of which then appear in the media in a way that prejudices the possibility of a defendant getting a fair trial. Something that actually in the UK, if it happened, would usually lead to a judge dismissing a case before it came to court, on the basis that the defendant would not have been able to receive a fair trial. This practice, which is outlawed in the UK, is common in Romania, unfortunately. Something that is one of the things that when I started looking at this shocked me most, if I'm being honest about it. Now, there are many, many cases that exhibit one or more of these features, but the case of Dan Adamescu that Willie referred to is significant because it features almost all of these abuses in one form or another. Dan Adamescu was, of course, owner of an opposition newspaper, Romania Libera, and Astra Insurance, the country's largest insurance company. He was targeted in 2014 after Victor Ponta, the then Prime Minister, had identified him as a political enemy in public. He said, this man is a supporter of President Băsescu. He talks about corruption, but he himself is corrupt, and you're going to find out very soon all about this. Within 2 weeks, he was arrested. Now, to my mind, that's very clear evidence that his prosecution was politically directed. And I think, again, in the UK, if that had happened, the case would have been dismissed before it came to court. He was kept in pre-trial detention, despite the non-violent nature of his offence. This is another tactic that the DNA use with the help of a compliant judiciary, is the very widespread use of pre-trial detention in circumstances that are not warranted in most cases. There was a denial of presumption of innocence, as referred to. Dan Adamescu was denied bail at his first hearing on the basis that he refused to admit his guilt. An absolute fundamental breach of judicial standards that Romania is committed to through various international instruments. He did not receive a fair trial. He was convicted on the testimony of a single witness who had admitted guilt, but had been given immunity in exchange for pointing the finger at Dan Adamescu. He was kept in filthy conditions in prison, and ultimately, as we know, he died of an illness contracted in prison after being denied proper medical treatment. And most shockingly of all, this last year we discovered that he's still being targeted in court. He's still a defendant in a case, having been subjected to a death sentence by neglect, in effect. He is being pursued and persecuted beyond the grave by the judicial system in Romania. And the case that this reminds me most strongly of course, is Sergei Magnitsky in Russia, who has suffered almost all of these things, including being prosecuted after his death. This is of interest to me coming from the UK because, as we pointed out, Dan Adamescu's son, Alexander, is being pursued in the UK through the European arrest warrant system. This European arrest warrant was issued very shortly after Alexander Adamescu had filed a case in the International Arbitration Court over the bankrupting of his family's insurance business, Astra Insurance. Quite clearly the two were linked. He's being pursued because he's an inconvenience. He's being pursued on the same evidence, despite the fact that he was in London at the time that he was supposed to have committed the offences for which he is being charged. The whole thing is a nonsense, but of course the British court system, under the terms of the European arrest warrant, is limited in the extent to which it can consider any of these issues in its final ruling, which is a point of concern that I'll come on to. Why these issues of concern to us and to the European Union? Well, first of all, they're a breach of European values and everything that the EU is supposed to stand for. The Copenhagen criteria, the Charter of Fundamental Rights, the European Convention on Human Rights, all of these instruments are being violated by the things that I've just described. Secondly, the Commission's reports under the Cooperation Verification Mechanism are not an honest assessment of where Romania is. They take at face value everything that they're being told by the DNA. They take a purely quantitative approach to assessing Romania's performance in the fight against corruption. Look at their reports. They will talk glowingly about numbers of convictions. There is no qualitative assessment of Romania's delivery of justice at all. None of the concerns and issues that I've talked about, that Daniel's talked about, that the Romanian Union of Judges has talked about, that very many other people talked about, are reflected in any way whatsoever in the European Commission's reports. In the same way that the European Commission verified Greece's national accounts when they allowed it to join the Eurozone, they are falsifying Romania's record on fighting corruption and delivering justice in order to ensure that they ultimately are able to join the Schengen system. And I think that should be of concern to the whole of the European Union. The European arrest warrant, I've talked about that already, is based on a dishonest premise in this case. The premise is that every country as part of the EAW system respects the same high levels of justice. Clearly that is not the case in Romania, and it's not the case also in a couple of other European Union countries as well. So once again, we have a well-intentioned European Union instrument that is undermined by the unwillingness of the European Union to really look honestly at whether or not its terms are being properly fulfilled. So what can be done? I think the following things. First of all, the European Commission needs to be pressured to be more honest about what's happening in Romania. European Commission officials need to be held to account and confronted with some of the evidence that is emerging about what's going on in Romania, denial of justice, a covert role of the SRI, collusion between prosecutors and politicians, the suborning of the judiciary to the pressure of prosecutors, etc., etc. That needs to be reflected in the European Union's assessments, and the CVM process needs to be overhauled. They need to ditch this purely quantitative approach to assessing performance, and they need to include qualitative indicators which will allow them to look more closely at what Romania is doing. Secondly, I think the Council should trigger the rule of law mechanism, which is meant to deal with member states that are in systematic breach of standards in respect of the rule of law, which will allow them to make some recommendations for how Romania can address some of these issues that I've talked about. Thirdly, on the EAW, I think there needs to be some scope for member states really to set aside the mutual recognition requirement in EAW cases when there is evidence that a member state is in systematic breach of standards of the rule of law, which Romania, to my mind, clearly is. And finally, as an issue for NATO, one of the requirements of NATO membership is civil control of the military. The SRI, the Domestic Intelligence Agency, is a military formation. It's quite clear that in Romania, civil control of the military does not apply, and that a part of the military, namely the SRI, has put itself in a position which no democratic intelligence agency should be allowed to be. So NATO needs to look at Romania's compliance with the terms of NATO membership in this specific respect. Thank you, and that's all I have to say this time, but I'm happy to answer any questions.
Thank you, David. Thank you, Daniel, for your testimonies and analyses that are really very impressive, and I think it's now time to open the floor to the participants in this round table. So, a question there. Please identify yourself.
My name is Crosby, Scott Crosby. I'm an advocate at the Brussels Bar. You mentioned Turkey and Russia. We know that in Turkey, defence counsel who represent people who are being accused of sympathies with the Gulen are themselves prosecuted and put in blacklists and put in jail, and some of them have to escape. Is this likely to happen in Romania, or is it happening already?
I have been aware of one case, I think, in which defence attorney has been pressured in this way, but I don't think it's as widespread as some of the other practices I've taught. I could be wrong. Maybe Daniel will correct me on that, but I'm only aware of one case where that has happened. But it's not impossible. There are no real safeguards to prevent it from happening in the case of Romania. Usually DNA and SRI will pick other mechanisms to get what they want, but certainly they're capable of it, and the one case that I'm aware of may turn out to be one of many that come in the future, unless some of these issues are addressed, and unless the system is reformed, and unless the prosecutors and the Domestic Intelligence Agency are required in some way to return to their proper functions. It's a risk, certainly.
Yeah. Other questions?
I will like to ask you a question. My name is Mitja Strădescu. I'm from Romanian television, Absolut TV. We have quite a few examples of political leaders who had to go to prison, and at the end of the trial they've been declared innocent, not guilty. This kind of situation, how can it be characterized in countries like UK, France?
I'm not sure what the question is, but I haven't looked at any cases where defendants have been acquitted, and I would need to familiarise myself more with those cases. It could be that they were simply acquitted on the basis of inadequate evidence, or in some cases, certainly I'm aware in other countries of cases where politicians have been acquitted in circumstances which give rise to suspicion that they've managed to bribe their way to freedom. But I don't know of any specific cases in Romania that fit that description, only because I haven't really looked at cases where politicians have been acquitted. I'm not aware of any recently anyway, but maybe Daniel will know better than I.
Yes, I will address it. I will give you 3 examples. The first example is a former head of a politician by formation, but a former head of the Insurance Financial Oversight Committee, let's call it, ASF is called, Mr. Dan Radu Rușanu. He was imprisoned for 6 months in pre-trial arrest, and he was acquitted for all charges, for no evidence. Now he's addressing the European Court to ask for compensation, and he asked for, I think, around 1.5 million euros for his 7 months spent in pre-trial arrest. That leads us to the situation of the responsibility of the magistrates, the people that you've seen in the streets supporting the DNA and supporting the freedom of the magistrates. They're not supporting the freedom, they're supporting the jail conditions. Second case, we have a mayor in Romania called Mircea Gută. He was acquitted in the first instance. He was acquitted in the second instance, and at the last instance, the Romanian High Court of Cassation and Justice, he was convicted 3 years in prison for corruption charges. He was in jail, and he did his time. After this, he submitted to the European Court, and he won. The European Court said that the decision against him by the High Court was illegal. So now he's trying to clear his name. Fortunately, the Romanians understood, because the Romanians cannot be duped so easily. Last year he was elected with about 60%, 70% again, after the European Court re-established, let's say, his name. What did the DNA do? They opened a new file against him. And I will give you the third example. I will have to use my example. When I was arrested, there were 6 or 7 charges against me. In the first court, I was acquitted of 5 of the charges and convicted for 1 of the charges, a silly one, and we are in appeal now. So this situation in Europe, to answer my colleague, my Romanian journalist here, these situations in Europe, European media in general cannot understand, for example, the fact that a journalist is an undercover agent of a service, and that a journalist, before you go to the DNA to be presented your charges, and there are documents in this case. I mean, you are summoned to the DNA at 9 o'clock, 9:30 you meet the prosecutor to present the charges. At 8:30 in the morning, certain journalists that I presented on my blog with proofs, they are connected to the security services, they start to present data from your file, intercepts or surveillance from your file, video files or audio files from your file, in order to present the public the fact that this person is guilty. What happens afterwards in the court? In 99% of the cases, in my case and in other cases, the video or the audio files are found to be tampered with. I mean, they are cutting certain words from the conversation, and they are preparing something in order to look okay for their files. So this is the way they are working. You mentioned corporate raiding. I just want to address one issue. By formation, I'm military. So we militaries, we tend to see things in white and black. Sometimes it's better. In conditions like this and in Romania, it's better. Why? Because always when you have an issue, you go back to the principles. So if our principles are democracy, transparency, control of the parliament, civil control of the activities, and free media, then it's simple. There is no corporate raiding law in Romania. So it's very easy for them to do such type of activities. It's not only the 2 cases that you know, David. I know dozens of cases when a prosecutor, hand in hand with the official of the security service, wants to destroy the business of one company. So it's very simple. The Romanian parliament should draw a corporate rating law very clear and very specific in this case. They mentioned civil control. There is an oversight civil control of the Romanian parliament, the committee, on the SRI. In December, the parliament asked the service to demote General Dumbrava that was involved in all these abuses. We are now end of January, there is no reply from the service. In December, in a very good stance, the commission said, in order to end all the discussions, when we had the hearing of General Dumbrava for 6 hours, we do not believe there is classified material. Let us declassify it and present it to the public. So we go back to the principles. Let's present it to the public. We are end of January, no reply from the Romanian intelligence. The case of the external service. The external service for the last year and a half has no director. The external service is run by military, by a general, who's running the service since 2005. So it's not only the case of SRI. What David said is extremely important, because instead of being, and this is the huge issue that I presented in the last month, we all know and we all admit that the intelligence services and the security services are extremely important for our nations. But instead of being involved in countering terror, we have ISIS going through Turkey into Europe. We have terrorist cells going into Western Europe through eastern routes, and I know what I'm speaking about. We have an influence from the east that starts to be more and more present. We have other threats. We have cybercrime. We have nuclear situation. We have big organized crime groups working in the area. Instead of focusing and putting the budget and dealing with the real threats, what the security services and the judicial did in the last year was misusing actually, those budgets and those activities in order to follow Romanian citizens that did not want to comply with their power struggle. Simple as this.
Yes, another question?
I'm part of freelance journalist. So can I just ask the speakers, it's been suggested that certain measures could be taken, such as considered postponement of the EU presidency of Romania, and both suspension of voting rights of its MEPs and a moratorium on its use of the arrest warrant. You briefly, I presume that each of you agree with the possibility of that. And David, you made quite what seems a serious charge against the EU of the Commission of falsifying Romania's record,
yes,
in order to pave the way for its entry into the Schengen. Maybe just explain that. You're thinking there, maybe a little bit, if you could, please.
Well, they're turning a blind eye to what's going on in Romania. The CVM reports are not an honest assessment of what's going on. As I said before, none of the concerns that have been expressed by me and by Daniel and by Romanian Union of Judges and by lots and lots of people in Romanian civil society are in any way reflected in the CVM reports. There's been extensive media coverage over the last year to show that the Domestic Intelligence Agency plays an unhealthy and indeed unconstitutional illegal role in directing the judicial system inside Romania for reasons that remain opaque but can nevertheless be discerned from various things that have emerged, including a motive of political control and possibly financial gain. None of that has been seriously addressed by the European Commission, who instead take at face value everything that is said to them by the DNA and by Laura Kövesi. That needs to change. And given the prominence with which all of this information is available to anyone who's prepared to look for it, I can only describe the Commission's accounts as falsified. They can't be unaware of this. They can't be, I think, seriously persuaded that none of this evidence is credible. What they're doing amounts to falsification, I'm afraid. Now, as to what can be done, I mean, I think denying Romania the presidency of the European Union, I wouldn't say they don't deserve that. What I would say is that there are a lot of steps that need to be taken before you get to that nuclear option. Lots of things that can be done on a smaller scale, one of which is to start being honest about what's going on and reflecting it in official European Commission assessments. Now, I understand the Commission's position. They find it often very difficult to be honest about what's happening in their member states because they don't want to attract criticism and pressure from member states. Although they're independent, they nevertheless, as we know, as anyone who's worked closely with the EU knows, the Commission are sensitive to the opinions and pressures from member states. It's not unusual what they're doing in relation to Romania. It's taken them a very, very long time to start really dealing seriously with what's happening in Hungary. That's been going on for 8 years now, and they're only just now beginning to get to grips with it. They've been in denial for many years. They've been slightly quicker in the case of Poland, but still I think it's taken them quite a long time to really get to grips with, far too long in fact, to get to grips with what's being done in Poland. And of course, now that it would have been easier for the European Commission to deal with some of these issues in 2010, 2011, when it started happening in Hungary, and when they were the only rotten apple in the barrel. Now that there's more than one rotten apple in the barrel, it's much, much harder for them to act. So that's something that the EU system needs to address, because it's going to become, unfortunately, a growing problem. Governance issues within the EU are going to become an increasing problem, precisely because it wasn't nipped in the bud at an early enough stage in the first place.
Yeah, I will have one question, but it will be afterwards. You wanted to ask
another question. Thank you very much. You mentioned briefly the term abuse of office. I understand that the DNA tends to use the abuse of office offence as a catch-all to cover many things that might be illegal, but on the other hand also might not be illegal. Can you say something about it? What is abuse of office in the eyes of the DNA?
First, there is no abuse of office. That is the bad news. Why? 1.5 years ago, the abuse of office was submitted as a text of penal code or criminal code to the Constitutional Court of Romania. The Constitutional Court of Romania ruled that this article is unconstitutional. The law says that within 6 months the government should take the measures in order to change the article. This did not happen. I don't have this abuse of law in my file, so I can speak freely because there is no idea that I might be influenced by it. So, if you go by the law, we are in a bleak situation. Instead, for the Romanian Parliament and for the Romanian government to gather the union of the judges, to gather the civil society, to gather specialists from Brussels, from Paris, I don't know, from London, from UK, instead of addressing the Venice Commission, instead of doing all the right steps and solving this legal problem, everybody is afraid of solving it because people will get out on the streets. On the other hand, these people that are getting out on the streets, they say, do not change the abuse of power article. Again, Constitutional Court, the highest court in Romania, said that this article is unconstitutional. We have to change it. The people that go out on the streets, they say, do not change the justice laws. They are perfect as they are until now. Why people should be afraid of change? These changes are not done in a secret office, like the protocols between the judicial and the security services. They are done in the parliament, openly, transparently, with people invited to say what they believe, and they finally are voted. If we do not believe in democracy, and we believe in the kingdom of Mrs. Koveshi, it's very simple. We go, we make a referendum, and we decide. But meanwhile, we are still a democracy. Abuse of power is an article that can be used by the DNA to convict anybody, civil, servant, politician, and even private. because it can be, and they tried to use it in private cases against private persons. Again, in my case, when I was arrested in January 2015, I did not have any position. I was not a politician. I was not involved in the political life. So what I'm trying to say is the following. Now we describe important cases, and it's very good. But there are hundreds of other cases that are not known. I am lucky to be here, and I had this opportunity to come here. But there are hundreds of Romanians that are not politicians. They are doctors, they are teachers, they are normal civil servants that were attacked by the DNA. The numbers are incredible. David mentioned the fact that before the elections there was a big attack against politicians. Romania has 41 counties. 38 of the 41 county presidents have a file with the DNA for abuse of power. 38 out of the 41. So, and their cases are abuse of power. Why? Because they signed a document and they said we have to do this bridge or we have to do this road. So this is not bribery. The DNA is not accusing them of receiving bribery behind or something or money. They're just saying, what is the result today? Nobody signs anything in the country because everybody is afraid, from the central to the local administration. I am talking to mayors, I am talking to people that are involved in the local administration, and they are telling, instead of signing this contract and then the DNA will come and pick me up, it's better not to sign it. And that's it. This is the reason why you see the investments in Romania zero. This is the reason why in 2017 we did not have 1 meter of autobahn or of interstate built. Nothing was built, actually. The only thing that was built was cases.
False accusation and acting unconstitutionally.
Exactly.
The abuse of office issue is an important one. 42% of DNA cases, on one estimate I've seen, are brought under the abuse of office concept, which appears in the criminal code without being defined. The Constitutional Court ruling stated quite clearly that abuse of office could only be used to prosecute cases where acts had been committed that were specifically defined as criminal elsewhere in the criminal code. And yet, despite that, abuse of office is still being used in a broad, unspecified way. In at least one case that I'm aware of, again in the UK, a European arrest warrant case against Gabriel Popoviciu. The Constitutional Court's ruling in this case is simply being ignored in relation to that case and in relation to the European arrest warrant against them in the UK. And it's quite clear that if you look at the cases, some of those 42% cases, that in many cases they relate to acts which would not be considered corrupt or even criminal in most countries. Sometimes they simply arise from incompetence, poor political judgment, administrative errors, in some cases genuine disciplinary offences but not of a criminal nature, etc., etc. But what abuse of office does is gives the DNA discretion to decide, in a sense, what is and what is not criminal. And that's a prerogative that they're very keen to hold on to. Laura Kövesi lobbied very, very heavily against the Constitutional Court's ruling, including making coded threats, which the official judicial representatives complained about. She was told off, in a sense, for inappropriately trying to influence the judiciary in advance of that decision. The decision still went against her. So now she has been attempting to prevent that Constitutional Court ruling being codified in a reform of the judicial code. That reform was one of the reforms that the government was trying to implement a year ago through these two very ill-judged and, to my mind, quite self-serving decrees that they issued and were then forced to retract. It was a sensible reform wrapped up in a lot of other reforms which were very poorly judged and, as I say, quite self-serving in their intent. But this issue has still not been addressed. This need to specifically define the abuse of office issue within the criminal code in line with the Constitutional Court's ruling.
Yeah, another question? There on the right.
Hi, I am Silvia, Legal Policy Officer at Dragomir Europe here in Brussels. In the context of the European Arrest Warrant, we do a lot of work. We've done a lot of work with regards to Romania and also with concern to pretrial detention and prison conditions. So I just wanted to make the point that, as you were saying, mutual trust and mutual recognition has been an issue for member states to raise this kind of problems in order to challenge the execution of an arrest warrant. However, in 2016 we had the Aranjosi and Calderaro judgment at the Court of Justice of the European Union, whereby member states can now conduct individual human rights assessments before they surrender the person. This has been the landmark decision, and now we've seen a lot of countries, a lot of member states systematically refusing to execute European arrest warrants to Romania on the basis of the European Court's Council for the Prevention of Torture report addressing the appalling poor prison conditions in the prisons in Romania. So, in a way, the fact that this is just in regards to the argument of the European Commission being dishonest and not having enough evidence to challenge and to address and talk about these issues openly. So for us and for lawyers across the whole territory of Europe, having that report for the CPG saying that the prison conditions are below the threshold of the Article 3 of the European Convention, that they amount to torture and criminal and inhuman and degrading treatment, that's justified refusing to execute and thereby not having that mutual recognition or mutual trust or belief that their human rights are going to be respected. We've seen Germany, we've seen Italy, we've seen the UK doing that. So this has publicly shamed Romania in a way, because these are really high-profile cases that hit the news in the UK. For example, Adamescu case was in the news for Adamescu's son for quite some time. So I'm just wondering whether there is anything being done in Romania at this point in order to, if there is anything that they want to, any initiative that they want to be seen to be doing something about the prison conditions or any other human rights that are presented in courts, any other human rights argument that are presented in court. Is there any initiative like that that kind of shed some light or bring some hope?
Well, the Romanian government used that as part of its reasoning for the decrees that it issued last January. But because in giving an amnesty to certain categories of convicted prisoner, it would free up prison space and allow them to address the overcrowding issue. I think that was quite self-serving, actually, because that's not the right way to do it. The right way to do it is to address the ridiculously high levels of pre-trial detention that are awarded in cases of non-violent crime, particularly to do with corruption. It's out of all proportion to what could be justified. Obviously, there are circumstances in which some defendants need to be put in pre-trial detention. For example, in mafia cases where there might be a suspicion of witness tampering through organised crime syndicates against particular individuals. But in countries like the United Kingdom, Germany, United States, it's an exception rather than the rule, as it is in Romania. Requests for pre-trial detention in Romania are routine in DNA cases, and they are routinely granted in DNA cases, and quite specifically in violation of accepted international standards, when there are plenty of alternatives to that available to courts. Yes, I'm aware of the court ruling, specifically in relation to prison conditions. I would like to see a right of member state courts to review European arrest warrant requests for a much broader range of human rights concerns to do with standards of justice, not just conditions, prison conditions. That's the first thing I would say. The second thing I would say is that, embarrassingly, the UK is not performing well on this. Other countries are using their discretion, I think, in a much better way than the UK is. Sadly, the response of the UK courts, when presented with overwhelming evidence that prison conditions are, in a sense, amount of degrading and cruel treatment, is to seek further assurances from the Romanian authorities that these issues will be addressed, particularly in relation to the person who is being surrendered under the EAW. That person is then, those assurances are given, the court accepts them, the person is extradited, and lo and behold, within a few months, it's quite clear that that person is being subjected to precisely the conditions that the Romanian authorities promised they would not subject them to. At which point the UK court, the reaction of the UK court is to say, well, we now need more assurances. So having been lied to repeatedly, the UK authorities' response is to invite a further set of lies and to take them at face value and believe them and surrender the individual to the same treatment that everyone else has been subjected to. So I think the UK has an issue in particular that it needs to address in looking at this.
I will add something, if you allow me, for this question. It's important. On 8th of October 2016, and I will send you the link if you want, because it is a video link. There was a meeting at the CSM, the High Council of Magistrates in Romania, that was mentioned before, the one that found David guilty. They found me guilty too for breaching justice independence, where the former Minister of Justice, Mrs. Pruna, she said on video with all the members of the council, and I quote, "I lied in front of the European Court. I gave them insurances that we will build 7 penitentiaries or 7 prisons. We do not actually have this money in the budget, so I had to lie." Now, Mrs. Pruna, former Minister of Justice, she's working in Brussels currently. She has a position in Brussels. Maybe she will know more about what lies have to be analyzed in order to explain to Brussels. Second, in December last year, a Romanian was extradited by UK, and he died after 2 weeks, after his extradition, in prison. The reason? He was not allowed, he did not have access to medical treatment. So that happened 2 weeks after he was extradited by UK. When I said European nations have to understand they are being an accomplice of this abuse of using the European warrants, I mentioned exactly for this reason. This person died in prison in Romania, and his lawyer and his family explained in Romanian TV the fact that they tried desperately for 2 weeks to provide him from their own home with their own money the necessary treatment for cancer that the prison was denying him. So these are the realities. What they are planning to do regarding this, I have a more strong opinion regarding this issue. A moratorium on the extraditions is extremely important for the first ground, the lack of a fair trial. Until we will discuss about the conditions, the pre-trial, the way the intelligence are behind, and how people are kept in prison, the lack of a fair trial in Romania is the most important. And I will add only one thing here. The media is very important for us. In Romania, each media owner has a file. Mr. Voiculescu from Antena 3, Mr. Adamescu, Romania Liberă, Mr. Sârbu from ProTV, and I can keep on with examples. All the media owners were targeted. All. There is not one to get away from this. Some of them were convicted, some of them were in prison, some of them are on the way to prison, and there are European warrants. This is a big question mark that you should think about. All the Romanian media is under this type of incredible pressure, and that goes to the journalists, of course, in order for them not to explain what is really happening in Romania. This is the reason why the European Commission should be more attentive to what the Romanian media is reporting.
Can I just add, actually, that in the case of the courts in the UK, I understand why they come to the decisions they do. They feel that their hands are tied by the European arrest warrant and the way that it's been transposed into British law. An Act of Parliament has declared that British courts must treat the decisions of Romanian courts as if they were their own decisions and respect them accordingly, according to the principle of mutual recognition. Therefore, judges are in many ways denied the ability and the discretion to exercise their own judgment in the face of the facts, and that's a big problem. I suggest that there is given that the high hopes on which the European arrest warrant was based, that all the countries of the European Union had converged around the same high judicial standards, given that those hopes have not been met and satisfied, I think the European Union needs to look again at the way that the European arrest warrant is structured to give member states more discretion to deal with situations in which one or two are departing from those standards quite seriously.
And I will add also another thing that the judges in UK, maybe it will be an interesting idea. There is a recording, a very short recording, 1 minute about, with former President of Romania, Traian, where he's speaking about how Mr. Voiculescu, for example, I'm just taking one example, was judged. In that recording, former President of Romania is talking to somebody and explains how the intelligence, how the security services came to him before the conviction, how they told him they will replace the judge, how they told him that the new judge is going to be Camelia, what is her name? Camelia Bogdan, a judge that is known to be affiliated with the security services, and how they said that the judge told them if she had another penal code, she would convict this person more than 10 years if it's possible. So before anything else, I think a judge in the UK that cannot understand this should listen to this tape where former president is explaining how the security services were ordering judges to convict people and send them to jail. The judge that was judging Mr. Voiculescu's case was arrested by the DNA from the court itself. He was judging the case. He was picked up by the DNA from the court. He was arrested. They replaced him with their own judge, and this is how they sent this person to prison. So before that, I think a British or European judge, it's interesting to hear this type of activities.
Just one point about the European arrest warrant. Last year we organized a conference on that issue, the misuse and abuse of the European arrest warrants, and also the flaws in its implementation, and a specific supplement to the Parliament magazine was published at that time, so there's a copy here at your disposal. But, I would have a double question. First of all, you said that when there is an inquiry by an international institution about concerning detention conditions, that the delegation can easily be fooled. What should be the methodology to be used by the Council of Europe Committee Against Torture next time they visit the detention facilities in Romania?
I would mention the methodology that was used by the current Minister of Justice in Romania, not Mrs. Pruna. We know her methodology. The current minister did not announce anybody. He put himself in the car without a driver. He drove in front of the prison, because the prisons are under the coordination of the Minister of Justice. He went to the guard. He presented himself. He showed his ID, that he is allowed to come and to enter and to see the premises. He entered and he picked up and decided himself which is the area and what are the rooms and the exact conditions. So it's very simple. His methodology proved to be very efficient.
I have another question about the European Commission and the CVM mechanism. There was a press release in November of last year in which Vice President Franz Timmermans was saying, with a diplomatic language, we have seen progress in some areas, but there is still more work to be done. Romania has met some of our recommendations, but there is not enough progress yet on others. I count on the Romanian government to pursue the necessary reforms and to avoid backtracking so that we can work together towards the goal of ending the CVM under this Commission's mandate. And in the middle of the press release, he recognizes that challenges to the judicial independence are a serious source of concern. So you said, both of you agreed to say that those reports, official documents coming from the European Commission were rather weak. What would you suggest to bypass the weakness of those reports and to raise awareness? Would you think, for example, of a shadow report that will, of course, would be different, by whom and in which context, and using what sort of documents to comfort?
I've read, I think, almost every CVM report that's been written about Romania, and although I'm aware of those sort of rather sort of diplomatic and coded criticisms which have been expressed in varying degrees of strength at different times over the years, but what Timmermans is talking about there, and what CVM reports of the past have when they've spoken in those terms, have been talking about, is the behaviour of the government in appearing to try to undermine the anti-corruption fight in Romania, which is a big question. I don't deny that that's an issue. I mean, the decrees that were passed last January, along with some things that were needed that I discussed earlier about to do with the abuse of office. There were a lot of self-serving reforms in there which were designed to create impunity for the elite to carry on with corrupt activities. So we have two problems in Romania. We have a corrupt elite that doesn't want to be prevented from behaving corruptly, and we have an anti-corruption bureaucracy which is itself corrupt and pursuing its activities for reasons that have nothing to do with fighting corruption in many cases. So both corruption and anti-corruption are Romania's problem. But the Commission is only referring to one of those problems. It's not referring to the way in which the anti-corruption fight has been corrupted at all. It's not recognised in any European Commission documentation, unfortunately. What would I like to see? Well, I'd like to see two things. I'd like to see the European Parliament conduct some hearings and call the Commissioner and call his staff and really just ask them, given the very strong and credible evidence that there's something wrong here with the way that the DNA are behaving, the role of the SRI, the way that they're suborning the judiciary, etc., abuses of process and standards of justice, etc. Given all of these things, why are you not reflecting it in your report? Why are you only focusing on one of Romania's problems and not both of Romania's problems? And the second thing I'd like to see is maybe the European Parliament conduct a thorough and independent inquiry into standards of justice in Romania of its own, in which it can call witnesses, it can call myself, not that I'm in anything like as much of a position of authority as Daniel and others who've been mistreated, Alina Bica, many other people who've been on the wrong end of this very dysfunctional Romanian justice system. The European Parliament should be looking at this and trying to get to the bottom of it and really facing up to, in a much more honest way, in a way that the Commission apparently just is unable to do, what's going wrong in that country.
I must tell you, for your information, that a few months ago, a few MEPs in the European Parliament had invited Laura Kövesi to testify about the work of the DNA. So when you say hearings at the European Parliament, that should be really very carefully prepared to have a balance in the among the actors who would testify.
Did she give evidence?
She talked a lot.
I must read the transcript.
So, to support the work at the DNA.
I must read this transcript.
Okay, I will try to find it. Yes.
So sorry, just a comment.
Yes.
Yes, parliamentary reports and inquiries might be interesting. But to what extent you say that the DNA/SRI have infiltrated certain institutions. Any evidence that they've infiltrated negatively the Council of Europe, for example? The reason I ask a question is that the Parliamentary Assembly prepared a report late last year, which in one passage suggested that the DNA was not respecting fundamental defence rights. When the final report was issued, that passage had been deleted, and no one quite knows how that happened so quickly and why. Any comment? I mean, how wide are the tentacles spread, and how deep do they go?
The tentacles are very wide, and they are very spread. There is an elite, as David mentioned, an elite of this judicial class that wants to hold power. The intelligence service, by the name service, has to be in the service of the nation for the national interests. The intelligence services started to be a power by themselves in the country, trying to rule the parliament, trying to rule the executive power. We lost 2 governments in the last year because of the involvement of the services, and trying to infiltrate and to control the judiciary. I would say that these tentacles are much wider than you expect. We have information, for example, in Romania, that cases of people that addressed to the European Court with abuses against them are shredded in the offices by clerks of Romanian origin that are working with the European Court. We have information that specific cases of opposition that are addressed to the European Union and to the European Court are signaled to specific I know about Romanian clerks that are trying to undermine, decredibilize, or delete these actions. So, again, the answer is that they will do everything is possible to preserve their power and to preserve their position. In terms of the hearings in the European Parliament, I totally agree, because it's very important for you to understand how this report is being done. They are coming to Romania and they are meeting the DNA representatives, they are meeting the DICOT representatives, they are meeting the Prosecutor General representative and Minister of Justice. One issue, and everything is prepared and everything is nicely put on the table for this report, already prepared amongst themselves. One idea would be for this committee, in this report, to see the union of the magistrates. One idea would be for this committee to see different NGOs that have a great activity in this area, that are supported by the media, and they present cases. And one interesting idea would be, because I heard last week the judicial inspection is starting the investigation regarding this issue, to address the Parliament Commission in the Romanian Parliament that is working now precisely on the collusion between the security services and the judiciary. The European Parliament hearings are very important, and I totally support this idea.
Just to talk about that specific example, I mean, that could be the result of some kind of covert intervention. We know those sorts of things happen. Anyone who's been involved in politics, for any length of time knows that these things happen in all political systems, in fact. It could be an example of that, or it could be an example of something else which I've detected, which is a kind of mental defense mechanism that Europe's elites have adopted to allow them to deal with or ignore uncomfortable truths that they don't want to face up to. And Europe has enormous problems at the moment. Europe and its member states domestically, we're all facing enormous problems. There is an overwhelming desire of people to believe that there are at least some things going right, one of which is the anti-corruption struggle in Romania, and huge resistance therefore to anything which might question that, because to no longer believe the propaganda of the DNA and its supporters that they're really fighting the good fight against corruption in Romania. yet it would to give up on that idea would amount to a kind of mental overload for them. It's just too much bad news to cope with. So they shut down mentally and block out anything which doesn't confirm this rather nice narrative that they've constructed. And breaking through that is extraordinarily difficult. But we've got to do it because we're not being true to what we as a European Union have been trying to achieve all these years. We're not doing ourselves any favours whatsoever by turning a blind eye to this. We're just storing up more problems for the future.
Last question, here at the back.
Yes, I found, my name is Matthew and I'm an extradition lawyer from London. I found your comment comparing the case of Dan Adamescu to Sergei Magnitsky very interesting. And this talk of corrupt elites within Romania and this talk of European elites not wanting to accept that Romania and Denmark might not have the same human rights record. Do you know if the Americans have a view on what's going on? Because obviously famously with the Magnitsky case, the Magnitsky list was prepared quite promptly and it introduced quite effective personal sanctions and travel bans for corrupt elites.
Well, when you talk about countries that have too many problems already to deal with on their plate, America certainly comes very quickly to mind. I don't know to what extent they are seriously engaged with this. I gave evidence to the Helsinki Commission of the US Congress last May, and I specifically mentioned the Adamescu case in this context because, of course, in America they now have a thing called the Global Magnitsky Act, which allows them to deal with these kinds of human rights abuses, not just in Russia, but in any jurisdiction and in any country. And I said, if you were looking for a case which echoed the Magnitsky case, then you would do very well to look at this specific case of Dan Adamescu in Romania. I don't know to what extent that has been absorbed there by the system. What I will say is that there are, in America, possibly even higher hurdles to confronting honestly what's happening in Romania than there are in the European Union, because American policy towards Romania has become securitized, very heavily securitized, which is to say that the overwhelming prism through which American government officials view Romania is defense and national security. It's a location for the national missile defense facilities. The SRI is very closely allied with the CIA. As we know, Romania cooperated with the Bush administration in these black facilities, these detention facilities for people that they've managed to apprehend during the war on terror, to keep them out of American jurisdiction so that they could torture them, etc., etc. Romania is regarded as a very strong ally of the American military-industrial complex, for want of a better phrase. That was Eisenhower's phrase, and I think it's pertinent here. American policy towards Romania is not driven by the State Department, it's driven by the Pentagon. And that creates a really serious impediment to America looking honestly at what's going on in that country, perhaps even more serious than the ones that exist within the EU, I'm afraid.
Okay, before concluding, you have been heard several times by a parliamentary commission in Romania. When is the report expected to be released, and do you have any concerns about its contents?
From the best of my knowledge, this investigation will continue at least until February, and we are expecting February, March, probably a report from the Commission. The first question that I was asked by the Commission after the first hearing was, because this Commission doesn't grant immunity or anything like this, was what do you expect from the Commission? So my answer was, I expect at the end you'll have a truth, a very clear report that will have legislative recommendations that will allow for these abuses not to happen anymore to any of us or to any other Romanian citizen. I believe that the Commission already has a lot of evidence, and I believe March we will have at least the first report to explain with very clear data when, how, in which cases, in which situations. Some of them were mentioned today, like the case of Mr. Voiculescu, of Mr. Popovici, of Dan Adamescu, and many, many others, because these are only the ones that are very public because of the names, where It was an illegal, abusive breach of the constitution, involvement of the security services in the judicial trial.
Yeah, thank you very much for your analysis and perceptions of the situation in Romania. As you said several times, I don't have good news. But we still hope that in the future we will all be able together, including journalists here, to raise awareness among those decision makers in the various European institutions that there is a serious problem in Romania, and that concerns directly the European Union, and that must be tackled seriously and very soon. Thank you very much for your presence here and your collaboration. Thank you very much for attending this meeting.